Swayam Prabha. Digital India. Educated India.
Good day everyone and a warm welcome to all our viewers. I am delighted to have you join us for this engaging and enlightening journey into the world of jurisprudence. I am Dr. Simranjeet Kaur, Professor and Principal School of Law, City University, Ludhiana. In today's lecture, we will discuss the foundation of legal system. So let's embark on this intellectual journey together and uncover the fascinating world of legal theory. So let's start. Law has different meanings as well as different functions. Philosophers have considered issues of justice and law for the centuries, and several different approaches or schools of legal thought have emerged. In this lecture, we will look at those different meanings and approaches and will consider how social and political dynamics interact with the ideas that animate the various schools of legal thought. We will also look at typical sources of positive law in the United States and how some of those sources have priority over others, and will set out some basic differences between the US legal system and other legal systems. So let's first discuss what is law. Law is the word that means different things at different times. Today we will discuss about Black's Law Dictionary. Says that law is the body of rules of the action or conduct prescribed by controlling authority and having binding legal force, that which must be obeyed and followed by the citizens, subject to the sanctions or legal consequences, is law. Now, let's discuss what's its functions. So, when we talk about the functions of the law, at the macro level, the law can serve to keep the peace, maintain the status quo, preserve the individual rights, protect minorities against majorities, promote social justice, and provide for orderly social change. Conversely, the law may keep peace at the expense of individual rights, maintain an ugly status quo, be used to oppress minorities, and so on. In a democracy, law ultimately reflects how society wishes to order itself, while in authoritarian governments, law is used to perpetuate existing power structures. In that sense, law and politics are deeply intertwined. At the micro level, law provides the rule of game for how businesses operate, restricting certain kinds of conduct and encouraging others. It can be used by businesses as a shield, giving them freedom to operate, and as a sword, such as when using litigation as a strategy against the competitors. Now, what's the relation between law and politics? In the United States, legislators, judges, administrative agencies, governors, and presidents make law with the substantial input from corporations, lobbyists, and diverse group of non-government organizations, such as the American Petroleum Institute, the Cider Club, and the National Rifle Association in the 50 states. Judges are often appointed by the governors or elected by the people. The process of electing state judges has become more and more politicized in the past 15 years, with the governing campaign contributions from those who would seek the justice with the similar political learnings. In the federal system, judges are appointed by an elected officials, the president, and confirmed by the other elected officials, the Senate. If the president is from one party and the other party holds a majority of the Senate seats, political conflicts may come up during the judges' confirmation processes. Such as division has been fairly frequent over the past 50 years. In most nation states, as countries are called in international law, knowing who has power to make and enforce the law is a matter of knowing who has political power. In many places, the people or the groups that have military power can also command political power to make and enforce the laws. Revolutions are difficult and contentious, but each year there are revolts against existing political legal authority. An aspiration for the democratic rule or greater rights for citizens is a recurring theme in the politics and the law. There are different schools for the philosophies concerning what law is all about. Philosophy of law is also called jurisprudence. There are many philosophies of the law and thus many different jurisprudential views, and the two main schools are the legal positivism and natural law. Although there are others, these two are the more influential in how people think about the law. Now let's discuss about the legal positivism, as law is considered as a sovereign command. We could examine existing statutes, executive orders, regulations or judicial decisions in a fairly precise way to find out what the law says. For example, we could look at the posted speed limits or most city roads and conclude that correct or right speed is no more than 25 miles per hour. Or we could look a little deeper and find out how the written law is usually applied. Doing so, we might conclude that 31 miles per hour is generally allowed by most state troopers, but that occasionally someone gets ticketed for doing 27 miles per hour in 25 miles per hour zone. Either approach is empirical, even if not rigorously scientific. The first approach, examining in a precise way what the rule itself says, is sometimes known as positivist school of legal thought. The second approach, which relies on the social context and the actual behavior of the principal actors who enforce the law, is akin to the legal realist school of thought. Positivism has its limits and its critiques. New Testament readers may recall that King Herod, fearing the birth of a Messiah, issued a decree that all male children below a certain age be killed, because it was the command of the sovereign. The decree was carried out, or in a legal jargon, the decree was executed. Suppose a group of citizens power in a particular place and commands that women cannot attend a school and can only be treated medically by a woman, even if their condition is life-threatening and the women doctors are few and far between. Suppose also that this command is carried out just because it is the law and is enforced with the vengeance. People who live there will undoubtedly question the wisdom, justice or goodness of such a law. But it is the law nonetheless and is generally carried out. To avoid the law's impact, a citizen would have to flee the country entirely. During the Taliban rule in Afghanistan, from which this example is drawn may did flee. The positive law school of the legal thought would recognize the lawmaker's command as legitimate. Questions about the law's morality or immorality would not be important. In contrast, the natural law school of legal thought would refuse to recognize the legitimacy of the laws that did not conform to the natural, universal, or divine law. If a lawmaker issued a command that was in the violation of the natural law, a citizen would be normally justified in demonstrating civil disobedience. For example, in refusing to giving up her seat to while a person, Rosa Parks, believed that she was refusing to obey an unjust law. Natural law. The natural law school of thought emphasizes that law should be based on a universal moral order. Natural law was discovered by the human through the use of reason and by choosing between that which is good and that which is evil. Here is the definition of the natural law. According to the Cambridge Dictionary of Philosophy, natural law, also called the law of the nature in moral and political philosophy, is an objective norm or set of objective norms governing human behavior, similar to the positive law of a human ruler, but binding on all the people alike and usually understood as involving a superhuman legislator. Both the US Constitution and the United Nations Charter have an affinity for the natural law outlook, as it emphasizes certain objective norms and the rights of the individual nations. The US Declaration of the Independence embodies a natural law philosophy. The following short extract should provide some sense of the deep beliefs in the natural law held by those who signed the document. The natural law school has been very influential in American legal thinking. The idea that certain rights, for example, are unalienable, as expressed in the Declaration of Independence and in the writings of the John Locke, is consistent with the view of the law. Individuals may have God-given or natural rights that the government cannot legitimately take away. Government only be consent of the governed is a natural outgrowth of this view. Now, let's discuss what John Locke says about it. Civil disobedience. In the tradition of Henry Thoreau, Mahatma Gandhi or Martin Luther King Jr. becomes a matter of morality over unnatural law. For example, in this letter from Birmingham jail, Martin Luther King Jr. claims that obeying an unjust law is not moral and that deliberately disobeying an unjust law is in fact a moral act that expresses the highest respect for the law. An individual who breaks a law that conscience tell him unjust and who willingly accepts the penalty of imprisonment in order to arouse the conscience of the community over its injustice is in reality expressing the highest respect for the law. One who breaks an unjust law must do so openly, lovingly, and with the willingness to accept the penalty. Dr. Martin Luther King Jr., legal positivist, on the other hand, would say that we cannot know with the real confidence what natural law or universal law is. In studying the law, we can most effectively learn by just looking at what the written law says or by examining how it has been applied. In response, natural law thinkers would argue that if we care about justice, every law and every legal system must be held accountable to some higher standards, however hard that may be to define. It is easier to know what the law is than what the law should be. Equal employment laws, for example, have specific statutes, rules and decisions about the racial discrimination. There are always difficult issues for the interpretations and decision, which is why courts will resolve different views. But how can we know the more fundamental ought or should of the human equality? For example, how do we know that all men are created equal from the Declaration of Independence? Setting aside for the moment questions about the equality of a woman or that of slaves, who were not counted as men with the equal right at the time of the Declaration, can the statements be empirically proven, or is it simply a matter of priori knowledge? A priori means existing in the mind prior to an independent of experience, or is a statement about equality a matter of faith or belief, not really provable either scientifically or rationally. The dialogue between the natural law theorists and more empirical oriented theories of what law is will raise similar questions. In this chapter, we will discuss how focus mostly the law as it is, but not without also raising question about what it could or should be. Other schools of the legal thought, the historical school of the law believes that societies should base their legal decisions today on the examples of the past. Precedents would be more important than the moral arguments. The legal realist schools flourished in the 1920s and 1930s as a reaction to the historical school. Legal realists pointed out that because life and society are constantly changing, certain laws and doctrines have to be altered or modernized in order to remain current. The social context of the law was more important to legal realists than the formal application of the precedent to current or future legal disputes. Rather than suppose that judges inevitably acted objectively in applying an existing rule to settle facts, legal realists observe that judges had their own beliefs, operated in a social context, and would give legal decisions based on their beliefs and their own social context. The legal realist views influenced the emergence of the critical legal studies. School of thoughts, the critics believe that social order and the law is dominated by those with the power, wealth and influence. The CLS school believes the wealthy have historically oppressed. In so doing, the wealthy have perpetuated an unjust distribution of both the rights and goods in society. Law is politics and is thus not neutral or value-free. The CLS movement would use the law to overturn the hierarchical structure of domination in the modern society. We begin our exploration of our laws and the legal system with the first course, an introduction to the Indian legal system. A legal system comprises of law which set out our rights, duties and remedies, and also the institutional mechanism by which these laws can be implemented and enforced. These include administrative machinery, the judiciary and the police. The Constitution of India is fundamental law of the land, and the content and functioning of our legal system is governed by our constitutional values. The basic premise underlying a legal system is the belief in the rule of law. In the first block, we will locate the concept of rule of law within our constitutional framework and explain it. We will read about the values enshrined in our Constitution that inform our legal system. We will impart a working knowledge of how we are governed and the role of citizens in democratic governance under rule of law. Our Constitution guarantees us certain rights, but at the same time also imposes some duties on us. This will form the subject matter of the second block. The makers of our constitutions have given us certain fundamental rights to enable us to live a life of dignity without any fear and to realize our full potential while guaranteeing civil and political rights. The Constitution provides a roadmap for the state in the form of directive principles of state policy for progressive realization of social and economic rights. An activist judiciary, however, has been interpreting the right to life, an omnibus fundamental right, to include rights such as right to health, right to clean environment. In the third block, we will introduce you to the institutions that have a mandate to make, implement and enforce laws. Separation of powers implies power sharing between the different organs of the state and that no organ becomes all powerful. Our Constitution sets out in detail the institutional arrangement for this power sharing. The bulk of the articles in the Constitution provide for various institutions such as legislatures, executive, judiciary, local government, election commission, attorney generals and comptroller and auditor general. All these institutions collectively provides the check and balances so essential for the success of our democracy. Lack of access to the legal system undermines the citizens' faith in the rule of law and affects the credibility of our legal structure to deliver the justice. This concern has prompted many efforts by both state and the civil society. In the fourth block, we discuss some select experiences and innovation to facilitate access to justice. Are we truly an inclusive society where socio-economic status does not dictate the extent of rights enjoyed by an individual? Is our system of governance people-centric, transparent and accountable? As we proceed with this course, we want you to approach it with the spirit of inquiry, with the preamble to our Constitution, providing the point of reference. The Constitution provides a dynamic value system which is subjected to constant interpretation and amendments. This block provides an overview and the rationale for the constitutional system that we have adopted. It introduces the values enshrined in our constitutions and the institutional mechanism for realizing these values. We will impart a working knowledge of how we are governed and our role as citizens in democratic governance under rule of law. A legal system comprises of laws setting out the rights, duties, remedies and institutional mechanism for enforcement of these laws, such as administrative machinery, judiciary, police and prisons. The basic premises underlying a legal system is the belief in the rule of law. We will explore the concept of rule of law in the first unit. We will identify the requirements of this concept, its application in a country and the debates surrounding the concept. The concept of rule of law needs to be understood in the Indian context and the light of our constitutional values. We will take you through the values enshrined in a constitution in the second unit on constitutional values our greatest strength. Is our democratic system? In the third unit, we will define democracy and describe democratic process in a country, including the conduct of election. We will see what democracy means for an ordinary citizen. The most important institution claiming political authority in the modern societies is the state and its legal system. Both in the legal and in political theory, the questions which are traditionally held to be the most fundamental are centered around the claim. What are the identification criteria for the rules belonging to a legal system? Can they be traced back either to the decisions of a supreme authority or to supreme norm? If the former holds, what is the locus of the authority in a particular system? How it can be identified? Can the supreme authority be identified in the legal terms without moving in a circle? If not, how can the decision of an authority identified in non-legal way acquire their legal force? If, on the other hand, the ultimate criteria of identification is a supreme norm, how is it itself identified by legal or by non-legal criteria? Is the supreme norm itself an element of the system? Can the authority of the supreme legal organs be limited by the legal rules? What are the identification criteria of those who limiting rules? Can they be traced back to the decision of the same authorities? Can they trace back to non-legal facts, to international law? How these can be the limitations be interpreted and enforced? If there are supreme norms or the norms defining the supreme authority in a system, can these norms be changed by the legal means? Can the authorities themselves change them? How can extra legal changes, for example, revolutions or conquest, create a new legal facts? Do these extra legal changes change the entire system? When does a legal system cease to exist? We really need to answer all these questions. Now, what are the normative reasons for the obedience to the law? What are the limits of such obedience? Can law itself provide the limit? Can there be the legal right to resistance? If so, how are those limits interpreted and enforced? Are there similar limits in the respect of the obedience of the supreme legal organs to the supreme norms? May these organs also overstep their legal limits? For example, in emergency cases. This list, I think, comprises the central problem of classical, political and legal theories. Roughly, we can classify the theories provided as answer to all these questions into two different groups. Theories which conceive legal political systems as a system of the norms or rules are called here normative theories. Theories which conceptualize legal political system as a systems of power and as a relations of authority prevailing between individual and groups are called decisionistic. This classification cuts across the traditional division in the legal theory. Hans Kelsen, the brilliant Austrian legal positivist, was a normativist. So were the most of classical theories of the natural law. Carl Schmitt, the German critique of the legal positivism, was a decisionism. Most representatives of the sociology of the law have been decisionist, but Max Weber, perhaps the greatest among them, was a normative. In this chapter, I shall try to present a short selective history of the questions and of the various theories purporting to provide answer to them. Hobbes' problem an adequate account of the ultimate foundation should provide an answer to the following questions. So, the questions are: what are the identification criteria for the rules belonging to the legal system? What does a legal system exist? What makes the rules belonging to the system binding? So, answer to all these questions must be found outside the system itself. A legal system can of course include norms which provide identification criteria for other norms or criteria for the existence of the system itself, or prescriptions concerning the normative force of the rules belonging to it. But we cannot answer these questions simply by pointing to these norms, for these norms themselves are the part of a system. In order to answer the questions, we must move into the meta level. The analogy between the question of the ultimate foundations in the jurisprudence and the distinction between object languages and the meta languages in the logic has been noted by the Ivory Wills and by the Julian Freud. Thomas Hobbes was one of the first theorists who clearly saw the problem of the ultimate foundations, and from his treatment of it, there is a direct route to H.L.A. Hart, whose theory is discussed in the next chapter. I'll start by presenting a logical reconstruction of a Hobbes inferential solution that I shall try to show how other theories in. So, I thank you for your time and attention. I look forward to our next session and chapters where we will continue to explore the fascinating concept of jurisprudence together. Thank you.